A question that I often get is, what is the difference between a revocable trust and an irrevocable trust? And once I start explaining that, people tend to be a little hesitant to want to do irrevocable trust planning. And the reason that you do irrevocable trust planning typically is asset protection purposes, as well as estate tax planning purposes or wealth transfer tax purposes. So today we're going to talk about how to make an irrevocable trust revocable. So let's get into it. So a lot of people are scared from doing irrevocable trust planning because they think that it lacks flexibility. It's kind of you set it and you forget it, right? Once you set it up, you're really locked into it. And if something happens, maybe there's a change in personal circumstances, maybe family dynamic changes, there could be a change in tax laws or trust laws. Despite that, you could be locked into this vehicle, this trust that doesn't work for you at some point along the way. So, if you set up a trust in, say, 2024, and 75 years from now, there could be a lot of changes, and maybe that trust doesn't work anymore. What do you do? Well, in the last 20 years or so, we've seen more changes in trust laws than we've seen in the last 200 plus years. And one of the modern approaches or modern advents in trust law is this role called a trust protector. And a trust protector is really important to adding flexibility to an irrevocable trust. And this is how all of a sudden an irrevocable trust becomes revocable or almost revocable. I'll explain what I mean by that here in a second. But a trust protector is really part of what's called a directed trust structure. And I have some videos about that, so check those out. I won't go into a lot of detail. But the idea behind the directed trust is that you're part and parceling, or you're cutting away the different trustee responsibilities, and you're handing them out to certain individuals that you think are best qualified in those roles. So the trust protector is kind of what's called the super trustee. And one of the important things to say here is that not every state has laws that allow for a trust protector. That doesn't mean that you can't include a trust protector, but there is some legal risk involved that should be considered when adding a trust protector to a trust in a state that does not have trust protector laws. South Dakota has really great, really strong, well-defined trust protector laws. And the reason that you want this is because it minimizes legal risk for everyone involved, including the trust protector. So if something goes wrong, then you're making sure that these individuals aren't going to be responsible for something they shouldn't be responsible for. And that is the case in these states that have trust protector laws. Okay, so what is the trust protector? It's the super trustee of the trust. That means that they're going to oversee the entire management of the trust. They aren't the trustee. The trustee is the entity or the person who's in charge of managing the various aspects of the trust. So that's managing the assets, making sure that the trust is administered according to the terms of the trust, and then also distributions, making sure that distributions are made according to the terms of the trust. So there's those three things: managing assets, distributions, and administrative things, right? And you could blow those out and talk about all those in great detail. So if you have a trust protector, you yourself cannot, you as the person setting up the trust cannot reserve the right for yourself to make changes to the trust, right? Unlike with a revocable trust, the client can reserve the right for them to revoke it, to amend it, to make changes to it, tear it up, start over, completely eliminate it, whatever they want. But you can, with an irrevocable trust, reserve the ability for the trust protector to make amendments to the trust, to revise provisions. In some circumstances, they can add beneficiaries, they can remove beneficiaries, they can decant assets from that original trust to another trust. So I kind of go into my example earlier. Let's say you're 75 years down the road and this trust no longer works for you. Maybe it makes sense to create a completely new trust and then decant assets from that first trust to the second trust. That means you're assigning assets from the first trust to the second trust. So now you kind of refresh the trust. Maybe making an amendment or an update to that irrevocable trust through the trust protector didn't make sense, and you just wanted to start completely from scratch and have a complete facelift to the trust, so you wanted a new one. So you could do that. So now all of a sudden you have the ability, you've reserved the right for someone else to be able to facilitate these updates, this facelift to the trust planning. So typically a trust protector, so who should be a trust protector? So it shouldn't be someone that's related to you, it shouldn't be someone that's subordinate to you, meaning like on your payroll, they're an employee of a business that you own. So sometimes it might be your attorney or your financial advisor, or it could be a really close friend, it could be your CPA, someone that you trust unequivocally. You can perpetuate the trust protector. So you can build out a succession plan. So maybe it's the trust protector has the ability to name a successor trustee, or maybe it's you name successor trustees, or you could even structure it as a committee where maybe there's 3 people on the trust protector committee, and if one passes away or becomes incapacitated, then the remaining 2 could nominate someone, and so it just continues to perpetuate itself over time. The trust protector could even veto distributions. So if you got the trustee that's making distributions to the beneficiaries, then the trust protector could even oversee that. So maybe that's why you might like a committee style approach to it. Either way, you got flexibility there. So through the trust protector, all of a sudden an irrevocable trust becomes revocable. Maybe not in the traditional sense, like with an actual revocable trust, but we have the flexibility there to do whatever we need to do, to accomplish whatever we need to accomplish. So I said that a lot of times people will name someone that they trust. What happens if you don't have anyone that you trust? So great question. And that's a question that people ask often. And in that case, what you do is you go ahead and you include trust protector provisions in the trust. You just don't name someone. And you could name someone else who has the authority to name a trust protector down the road. You could give that authority to the beneficiaries of the trust, if that makes sense. You could reserve the right for yourself to name a trust protector down the road during your lifetime. Or if all else fails, you could say that the beneficiaries could petition the court to name a trust protector, and in that situation, the beneficiaries would say, hey, we want John Smith or Jane Smith, whoever it may be, to be trust protector, and per the provisions of this trust in, Article 12, it says that we have the authority to do this, and, your attorney would submit the paperwork to the court, they would name a trust protector, and then you could make whatever updates that you need to make. So either way, there's a contingency plan for your contingency plan for your contingency plan through the trust protector. There's a lot of flexibility there. Some attorneys don't add trust protectors. Maybe they've been practicing for 30, 40, 50 years, 60 years, and the trust protector is something they didn't grow up with, or maybe they don't fully understand it, or maybe they say there's legal risk there. And there might be some legal risk there. But either way, the client should be the one making that decision. In anything that you do, there's going to be legal risk. And some attorneys are so prone to avoid any risk whatsoever that they don't present certain options to clients. But I think it's really important to give the client options. And then you can really start focusing on what their intent is and what's really important to them. And then you can come up with a very specific customized plan for the client. So if someone's not talking to you about trust protectors, maybe have that conversation, bring the conversation up. But if flexibility is really important to you, then I think this is something that you want included in your trust planning.